Who is acting as the host?
Good evening, sir. Jsslc.
Good evening. Jhalak, my suggestion is make me a co-host so that I'll be able to share my screen at the appropriate time. And I can mute or unmute myself on my own.
Yes, sir. We have made you the co-host.
Oh, okay. Thank you. Thank you.
Yes, sir. So with your permission, shall we begin, sir?
Whenever you feel okay.
Sure, sir. Sure, sir. Thank you. A very good evening, everyone. At the outset, I wholeheartedly welcome Shri Sjslc Gandhi, sir, an eminent and foremost RTI activist of India and a former Central Information Commissioner, to the Neeti Talks. We welcome you, sir. I welcome our Chief Executive, Professor K.S. Suresh, and our Principal, Dr. S. Natraju, Senior Faculty Members, Professor Jagdish Neeti, Professor Nagendra, Faculty Coordinator of the Neeti Talks, Sneha Jagdish, all faculty members, students, attendees, and viewers. Welcome to the Neeti Talks. I now request Jhalak Darla, the moderator, to take over. Over to you, Jhalak.
Thank you, sir. Good evening, everybody. My name is Jhalak Darla, and I will be the host of the day. I would like to welcome everyone on the Neeti Talks on Right to Information by Shri Sjslc Gandhi, former Central Information Commissioner. The Neeti Forum, where experience speaks, is a knowledge-based initiative which will serve the participants by efficient and accessible administration of knowledge. Let's start by reviewing today's agenda. We will begin by welcome by the principal of Jsslc Law College Autonomous, Dr. S. Natraju. Thereupon, Ms. Navya will be called to introduce the chief guest, who undeniably does not require any kind of introduction. Following the introduction, Shri Sjslc Gandhi will be addressing the gathering with his valuable diction. The participants can raise questions provided they type their name in the chat box, from where our volunteers will take it forward. Mr. Pratyush will then be called upon to render the vote of thanks. I request Dr. S. Natraju, Principal Jsslc Law College Autonomous, to give a warm welcome to the chief guest of the day.
Okay, thank you, Darla. Ellargu namaskara. Good evening, everybody. At the outset, I express my respectful pronouns to Sri Suttur Guru Parampara and seeking the blessings of His Holiness Jagadguru, Sri Shivaratri Deshikendra Mahaswami Galavaru, the present pontiff and the president of our JSS Mahavidyapita, Mysore. Respected distinguished speaker of the day, Shri Sjslc Gandhi sir, and Professor K. Suresh sir, the chief executive of our college, all the faculty members, the students, and all the participants who have attended this webinar. The Neeti Forum is constituted as a part of IKSC initiative of the college, and also with the objectives to have a knowledge-based initiative to serve the students and faculty by efficient and accessible administration of knowledge for all. We have started this Neeti Forum from this year with the initiative of the faculty and students. It was taken a good view by the inauguration, and it was done by Honorable Mr. Justice Kurian Joseph last month. This is the fourth lecture series through this Neeti Forum, and I hope it will continue further with innovative programs in the days to come. So we have fortunate to have a distinguished speaker today. Is none other than Shri Sjslc Gandhi sir, RTI activist, former Central Information Commissioner. He was kind enough to accept our invitations, and he is going to enlighten us on the topic, the RTI, Right to Information Act. So this is a very important act, and it's very useful to not only the law students, but all the stakeholders and common man. Sir, on behalf of our college, the management, staff, and students, and on my own, I extend a hearty welcome to you, sir. I welcome you, sir. I also extend a warm welcome to all our faculty members, students, organizers, and one and all. Thank you.
Thank you, sir. I now request Ms. Navya to introduce the chief guest for the day.
Good evening, everyone. I, Navya Shri, consider it as my privilege to introduce Shri Sjslc Gandhi to the audience. Shri Sjslc Gandhi, a man who likes to call himself a citizen empowered by RTI, is one of the country's foremost voices for right to information, transparency, and accountability. Shri Gandhi is an eminent right to information activist and a former Central Information Commissioner. He completed B.Tech in civil engineering from IIT Bombay in 1969 and was a first-generation entrepreneur. In 1980, he established the Clear Plastics Limited that grew to a significant size, employing 500 people and used only indigenous machinery. However, in 2003, he sold the business and started focusing on right to information. Since then, he has evangelized it with zeal and vigor. T. Gandhi is one of the prime movers of the national RTI movement involved in drafting the National Act. He was the convener of the National Campaign for People's Right to Information. He has trained citizens and government officials on how to use RTI by conducting thousands of workshops. Sir is the only RTI activist to have been chosen as Central Information Commissioner. During his tenure as Central Information Commissioner, he has delivered many landmark decisions on RTI and has a record of disposing of over 20,000 cases in 3 years and 9 months and ensured that most cases were decided in less than 90 days. Sir is the one who organized the first digital paperless office in the Commission. He is passionately pursuing the cause of evolving ways for a time-bound justice delivery system and improving the governance systems. In 2007, IIT Bombay conferred upon him the Distinguished Alumnus Award, and Sir is also a recipient of Satyendra K. Dubey Memorial Award in 2010 by IIT Kanpur. Among many other awards, he is also the recipient of the Nani Palkiwala Civil Liberties Award and the MR Pai Award. Sir has authored a book, RTI Act, Authentic Interpretation of the Statute, and a paper critiquing Supreme Court judgments on right to information. Shri Sjslc Gandhi continues to be a crusader for transparency and integrity in all public matters. Today, Jsslc Law College Autonomous and the Neeti Forum feels honored to have Sir with us. Thank you.
Thank you, Navya. We learned so much from the brief introduction. I can only imagine how much more will we be able to learn today. May I now request Shri Sjslc Gandhi to grace the occasion by his beneficial words.
Fellow citizens of India, we say we are the world's largest democracy. When I was in school, I was taught that democracy is rule of the people, for the people, by the people. And I don't think the definition has changed any. I've asked people across the nation if they feel they are rulers of this nation. If you go to a government office, do you think you are treated as the ruler of a nation? And the universal answer is no. Nobody treats us like the ruler. If you write a letter, do you get a response? If you send a complaint, do you get a response? And in most cases, the answer is no. Then how are we a democracy? Is a question I would like to pose before this audience. If you are not the rulers of this nation, if it's not rule of the people, for the people, by the people, how do we say and claim that this is a democracy? Are we a sham democracy? We say we are the world's largest democracy primarily because we have a constitution and we have a reasonably fair and good system of elections by which we are able to change our elected representatives and governments. We've done that, and that's true. I would submit to you that having elections, fair elections, and a constitution by themselves are necessary conditions for a democracy, but are not the complete set of conditions. The heart and essence of democracy is the concept that each individual citizen is a sovereign in her own right, and she gives up part of the sovereignty to the state in return for which she gets a rule of law. Sovereignty of the individual, ruler of the nation, is the key to a democracy. Each one of you, my friend, should feel like a Badshah or Begum when you deal with the government. We say this is Lokshahi. Lokshahi can only have one meaning, Logon ki Shahenshaahi. If that is not true, we are not a Lokshahi. You own the government. This is the key thing that I want you to carry with you. You own the government, you own the nation. You are the owners, you are the rulers of this nation. In one college, I was giving this talk where it was a live talk, and one young student got up and said, Mr. Gandhi, are you seriously saying we are rulers of this nation and we are owners of the government? I said, yes. So it's supporting, I like a government car, can I take it home? I said, you can't take it home. He said, so then you are not telling the truth. If I own the car, if I own the government, everything in government belongs to me. Why can't I take the car home? The reason I explained to him was because this car and this government property you own in conjunction with 140 crore other Indians. So therefore, if you take away something, it is at the cost of the others. But, and this is important to understand, information in the cupboards, computers, files of the government also belongs to us, also belongs to me individually. And if it belongs to me, if it is given to me, it does not cause loss to anybody else. The same information can be given to 100 people. Therefore, when I ask for information, I'm seeking information that belongs to me. Right to information, in my opinion, is that single tool which has the potential of transforming our defective elective democracy into a truly participatory democracy, the Swaraj that we talked of. That is the potential of it. It changes the whole power equation between those who are ruling, those with power and money, and the ordinary citizen. It recognizes that you have a right. You own the information because you own the government. Brief history. The first such law in the world was enacted in Sweden on 2nd December 1776, nearly 250 years back. After that, for nearly 1.5 centuries, no such country had such law. Now over 120 countries have such laws. They go by 3 different names. ATI, access to information, FOI, freedom of information, or right to information, RTI. We call it RTI. These are synonymous words for the same concept, that transparency of government is an essential part of democracy. In India, incidentally, this movement started not in cities, not in colleges, but it started in rural Rajasthan. 3 unique people got together. Aruna Roy, an IAS officer who resigned her job to work with people in rural Rajasthan. Nikhil Day, a young lawyer who had been trained in USA, who joined her and who was about 20 years younger to Aruna Roy. And Shankar Singh, a local person of Rajasthan, who was staying in a village. They got together and started explaining the concepts of democracy to the people. And that is how the right to information movement started somewhere in 1991-92. Today, it's a national law, and I will take the pleasure of walking you through some of the key provisions of the law. The law is extremely simple. I'm not a lawyer, as Navya suggested. I'm just a stupid engineer. But how am I talking about law? Let's look at the law. It's a very simple law to understand, and keep the basic thing in mind. You own the government, therefore the default mode is all information belongs to you. Everything belongs to you. Okay, I'll now try and share my presentation. Just give me a few seconds. Is it visible?
Yes, sir. It's visible.
Okay, the Right to Information Act 2005, this was passed in 2005 and became operational from 12th October 2005, which incidentally was Vijayadashmi, a very significant day for India. Let's walk through some of the key provisions of the law. The preamble is a very important part of a law. And this preamble says, whereas the Constitution of India is established democratic republic, and whereas democracy requires an informed citizenry and transparency of information which are vital to its functioning, and also to contain corruption and to hold governments and their instrumentalities accountable to the governed. And whereas revelation of information in actual practice is likely to conflict with other public interests, including efficient operations of the governments, optimum use of limited fiscal resources, and preservation of confidentiality of sensitive information. And whereas it is necessary to harmonize these conflicting interests while preserving the paramountcy of the democratic ideal. The law harmonizes this. I've come across some people who say it means we have to harmonize, each one will harmonize. No, what is meant is that the law will harmonize these conflicting interests, and the law has done it beautifully well. All information default mode belongs to people and must be given to them. There is a small negative list which we'll take a look at of information that shall not be given because it is expected to protect certain limited interests which must be protected. What is information? This is extremely important to understand. Information means any material in any form, including records, etc., etc., and data material held in electronic form, and information relating to any private body which can be accessed by a public authority under any other law for the time being in force. The law talks later of who has to provide information, but a normal private body which has no connection, which is not funded by government, which is not controlled by government, does not fall in the category of public authorities who have to give information. But information that a public authority may have of such a private body can be accessed by a citizen. To give you one simple example, cooperative housing societies, normal cooperative housing societies are not public authorities and are not expected to give information in RTI. But information that they file with the registrar of cooperative societies or trusts, information which is held by the charity commissioner, is accessible to the citizen. But the key thing is information must exist. What exists is information, what does not exist is not information. Therefore, if you ask under right to information, what is the meaning of this law? No response will be given because it is not defined in any record what is the meaning of that particular law. If you say, if I apply for this job, will I get this job? Questions like that, unless there is something on record, no information exists. What exists is information. Public authorities, who has to give information? Section 2(h) says public authority means any authority or body or institution of self-government established or constituted by or under the Constitution, by any other law made by Parliament, by any other law made by state legislature. A, B, and C effectively mean everything that we call government, including municipal corporations, panchayats, central government, state governments, all of these. And any institution created by a law of Parliament or state legislature. For example, the Sikh Gurudwara Prabandhak Committee is a creation of Parliament, and therefore it's a public authority. By notification issued or order made by the appropriate government. Deemed universities, for example, are created by a notification issued by government specifically for that deemed university. Therefore, these are public authorities and have to give information. Or order made by the appropriate government, and includes any body owned, controlled, or substantially financed, non-government organization substantially financed directly or indirectly by funds provided by the appropriate government. Any what we call private body, if it is owned by government, it is a public authority. If it is controlled or substantially financed, it's a public authority. There is a considerable confusion and controversy surrounding the PMKS fund just now. The PMKS fund says it's not a government body. Fair enough, let's concede that. It's not financed by government, conceded that. But it is controlled by government. The Prime Minister of the country, ex officio, is the chairman of the trust. 3 other ministers, ex officio, are trustees. When somebody takes an ex officio position, he or she is supposed to represent the person from where he draws his authority. All the Prime Minister and 3 other ministers draw their authority from the fact that they are ministers in the government of India. It would be tried to say that they do not represent the government's view. They can only represent the government view and nothing else. They cannot represent their private views. Therefore, it is a public authority and should come under RTI. Without following the law, they are refusing to, and it's a very powerful body, so it's very difficult to bring them under the law. Right to information means the right to information accessible under this Act, which is held by or under the control of any public authority, and includes the right to inspection of work, documents, records. You can inspect work. Let's say there is a road which is very bad, or a hospital which is very bad. In fact, a young student in Mumbai has done that. He said he wants to inspect a government hospital. He got records of the costly equipments there and checked whether they were working, etc., and made a report. If a road is very bad and there's nothing on record, you can ask for an inspection of the road with the municipal authorities or whoever the authority is and make a report describing the bad condition of a road, and then you can pursue the matter. You can go to a government office and say, I want to inspect files relating to ABC, whatever subject. Taking notes, extracts, or certified copies of documents or records. 90% of RTI revolves around this. People take copies of documents or extracts from documents. Taking certified samples of material. You can also take samples of material. For example, if you feel the medicine in a government hospital is of bad quality or of expiry dates, you can take samples and get it tested. If you think road work is going on and the concrete is of poor quality, you can take a sample again and get it tested somewhere. Obtaining information in the form of diskettes, floppies, tapes, etc., etc. CCTV footage is also included, and this is a very important source of information because a lot of things now are covered by CCTV. The most important section of the RTI Act is Section 3. Subject to the provisions of this Act, all citizens shall have the right to information. Who shall have the right to information? All citizens. It's a fundamental right under Article 19(1)(a) of the Constitution. Article 19(1)(a) talks of freedom of speech and expression. A catena of Supreme Court rulings has held that this includes right to information and right to publish. Media's right also comes from Article 19(1)(a). Right to freedom of speech comes from 19(1)(a). And right to information also draws from Article 19(1)(a). If all citizens shall have the right to information, because we own the government, can any information be denied? If I own everything, why should any information be denied? Subject to the provisions of this Act. Only the provisions of this Act will decide what information is not to be given, which comes under Section 8 and 9. Section 9 covers copyright, so I'll not be dealing with that. If, let's say, somebody asks government censor board about a copy or DVD of a film, that would not be given since it would infringe copyright, or photocopy of a copyrighted book would not be given. Apart from that, it's only 10 sections in Section 8(1), which we'll deal with in a little more detail. Section 4 is the heart of the RTI Act. What was envisaged, and this was made in 2005, nearly 16 years back. Every public authority shall maintain all its records duly catalogued and indexed in a manner and form which facilitates the right to information under this Act, and ensure that all records that are appropriate to be computerized are, within a reasonable time and subject to availability of resources, computerized and connected through a network all over the country on different systems so that access to such records is facilitated. This is a dream which should have come true by now. 16 years have passed. And I'd like to look at this latter part of this provision. Computerized. In 16 years, almost everything has been computerized everywhere. Every district court has a computer. Every panchayat office has a computer. Every government office has a computer. And most of them are connected with a network. Reasonable time, 16 years have elapsed. A common experience you would have heard of is a citizen goes to a government office to find out about his complaint or application or some representation he has made. And he might be told, file nahi milta hai. If he gives 100 rupees, the file may surface. If he gives 500 rupees, he may be allowed to look at the file. For 1,000 rupees, the record can be removed. And for 5,000 rupees, the entire file can be made to disappear. All this need not happen. This can stop. Computers are there everywhere. Everything should be done on a computer and electronically transferred over the network. No paper should be used. This is something which is entirely possible and feasible, in which case every work done in every office every day by evening could be on the internet. And therefore it should be true transparency without additional efforts by anyone. Even if a citizen does not know how to use the internet, he or she may ask the public information officer, can easily access it and give the information on a printout. This was the dream of the RTI. that most information would be available freely and automatically. But this has not unfortunately happened. I'm hoping all of you will realize. Let me also tell you one other aspect of this. The total amount of government work that goes in uses phenomenal amounts of paper. So thousands of crores are spent on paper and files. A comparable amount is spent on on space for keeping these files, and a relatively comparable amount on finding these files. All of which can be saved if the whole thing is done computerized. And as a side benefit, not a side benefit, a major benefit, lakhs of trees would not be cut every year to satisfy the needs of paper. Think about it. It's a great thing that was promised, but it has not been enacted. Right now, the way it is looked at, 17 points under 4.1b, such other information as may be prescribed. The heart of the RTI Act, unsatisfactory implementation. Computerization has happened, money has been spent, but it's not being used properly. Proper implementation could improve working efficiency. It would also make the PIO's job easier. Over 50% RTI applications, a survey has found, seek information which should be available under Section 4. Fair enough, we've understood we have the right to information. Who do we ask for information? The law says that every public authority shall have a public information officer in all administrative units or offices under it as may be necessary to provide information to persons requesting for the information under this act. You don't have to worry. All you have to think is A, what information do you want which is likely to be on record? B, which department is likely to have it, and if possible, which particular office may have it. The law says you must apply to reasonable office where the information is likely to be. If the information is not with that officer or office, then can you return the RTI application to you? The answer is no. The law requires him to get information from other people in the same department and provide it to you. Supposing it's in a completely different department, you've asked some information from the police department and the information is actually with the municipal corporation. Then also the RT application cannot be returned to you. You are the ruler, you are the Badshah or Begum. The PIO must transfer the RT application within 5 days to the correct PIO. You must think logically and carefully as to which office is likely to have the information. We don't want to overload our government. It's our government. But in case you are not able to locate the right office or the right officer, the law ensures that the RT application will not be returned to you, but will be transferred and information must be provided to you within 30 days. A person who desires to obtain any information under this act shall make a request in writing or through electronic means in English or Hindi or in the official language of the area in which the application is being made. The local language of each state would apply. An applicant making request for information shall not be required to give any reason for requesting the information or any other personal details except those that may be necessary for contacting him. Quite often, government officers say this is not a fair position to take, that this provision is wrong. Without any reason, why should a citizen harass me? The argument is fairly simple. You are the owner of the information. The government public servant is the keeper of the information. If there is a cupboard in your house, can you open it 100 times to look for something in it? The answer is yes, you can. Similarly, it's up to you. You can look at it a number of times and you do not have to give any reason. It is extremely important to understand. This RTI recognizes that no reasoning is required. If I have to give reasons to seek information, tomorrow I'll be asked to give reasons to speak. The third day I'll be asked to give reasons to publish anything. This is my fundamental right. And nobody can ask me to give reasons and explain the locus standi for seeking information. On receipt of a request under Section 6, PIO shall as expeditiously as possible in any case within 30 days of the receipt of the request either provide the information on payment of such fee as may be prescribed or reject the request for any of the reasons specified in sections 8 and 9. Categorically, the law says information can be refused only on the provisions of section 8 or 9. 9, as I told you, is copyright. 8 we'll deal with. Apart from which, no other information can be refused. There's generally an application fee. In most places, it is 10 rupees. Each state can have its own fee structure. Each high court can have its own fee structure. Most cases, it is 10 rupees. Central government is also 10 rupees. The simplest way of paying the 10 rupee application fee is by Indian postal order of 10 rupees. In most places, that's accepted. If the information is, let's say, 200 pages, the PIO, again, in most cases, the fee is 2 rupees per page. So if it's 200 pages, the PIO will inform you that please pay 200 multiplied by 2 rupees, 400 rupees. He must give you the calculation and ask you to pay the money. And the moment he makes that request, the 30-day clock stops. After you pay the money, the 30-day clock starts, and we'll take a look at this in the next slide. If PIO fails to give decision on the request for information within the period specified under subsection 1, PIO shall be deemed to have refused the request. In case he doesn't respond in 30 days' time, then what happens? It is a deemed refusal without any reasons which should attract the penal provisions of the law. We'll take a look. PIO must give details of further fees, which I explained to you. Person making requests for information shall be provided the information free of charge, where a public authority, if in 30 days information is not provided to you, even if the information is 5,000 pages, nobody can charge you 10,000 rupees. The public authority will have to supply it free of cost. 30-day period, I thought I'd explain in this manner because it's important to understand. PIO receives RTI application is day 1. After X days, PIO sends letter asking additional fees, 30-day clock stops. Additional fees paid, 30-day clock starts again. Information sent after Y days, X plus Y less than or equal to 30 days. If RTI application is transferred, the period they get is 35 days. And if the period is exceeded, the information has to be given without any extra charge. Now, I've given a good RTI application is focused. You have a purpose in mind. It may be research. It may be because you suspect corruption. You want to get something corrected. You have a purpose in mind. Based on that, make it very brief. A good focused brief RTI application gets overall better results. I've given some examples. The PPT is going to be shared with you, so you can take a look. Most of these are over in less than 50 to 100 words. And if you have it focused, the chance of your succeeding in RTI and getting the information properly is much higher. These are again examples of RTI applications. Okay. RTI is a fundamental right of citizens under Article 19(1)(a), which guarantees freedom of speech and expression. Various Supreme Court judgments have held that this includes right to information and right to publish. Now, can any restriction be put on my fundamental right? If the Constitution allows it, then you can put it, not otherwise. The only permissible restrictions are given in Article 19(2), which permits reasonable restrictions in the interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency, or morality, or in relation to contempt of court, defamation, or incitement to an offense. These are the only areas in which some reasonable restrictions may be put on my right. And the provisions of Section 8(1) basically follow this. And in case of a doubt of interpreting something, my submission is you must look at Article 19(2) and see what could be the meaning of that, and we'll deal with this. Section 8(1). This is about 380 words. If you understand this, you understand RTI. Notwithstanding anything contained in this act, there shall be no obligation to give any citizen information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, or economic interests of the state, relation with foreign state, or lead to incitement of an offense. This is often used in a very loose manner. They just say Section 8(1)(a). Somebody has to show how it will affect the security of the state strategic interests of the state or economic interests of the state. Without that, Section 8.1a denial is illegal. 8.1b. Information which has been expressly forbidden to be published by any court of law or tribunal on the disclosure of which may constitute contempt of court. A lot of RT applications are often refused by saying the matter is sub judice, hence we will not give you information. Wrong. This is not as per the law. The law categorically did not use the word sub judice. Parliament knew the word sub judice. It said information which has been expressly forbidden to be published by any court of law. So there must be a specific court order saying this information is not to be shared. Alternately, impliedly, if a case is handled in camera, then obviously it would be forbidden and therefore it cannot be disclosed. All of the information has to be disclosed and sub judice cannot be a ground for refusal. C. Information, the disclosure of which would cause a breach of privilege of Parliament or the state legislature. What kind of information is this? For example, the budget papers. If you see the budget papers details before the budget is presented, it would be breach of privilege. Similarly, Commission of Inquiry reports by Commission of Inquiry Act are supposed to be submitted to the Parliament or state legislature within 6 months of receipt of such reports. So the first 6 months, if it has not been presented to the Parliament or state legislature, it could be refused to you. But, and this is important to understand, quite often governments do not place a Commission of Inquiry report in Parliament or state legislature. After the period of 6 months is over, they have already committed breach of privilege and therefore the information must be shared with you. There are instances where this has happened before. An RT application pressurized the government into placing it on the floor of the legislature. D. Information including commercial confidence, trade secrets, or intellectual property, the disclosure of which would harm the competitive position of a third party. There is a larger public interest override which we'll deal with later. It must, supposing you ask FDA for a detail of the formula of Coke, it may be refused to you because it is on the nature of commercial confidence, and disclosure would harm the competitive position. Both conditions have to be satisfied. Only one condition cannot be sufficient. To give an example, for information regarding, say, Bank of India or Air India, this could be used to deny information because they have a commercial interest, they are also in competition. But Indian Railways cannot use this because they are not in competition. Before a tender is awarded, this clause may be used. After a tender is awarded, this clause cannot be used because nobody's competitive interest would be hurt. Information available to a person is fiduciary relationship. Now, what is fiduciary? Most government servants do not understand what fiduciary means. Most citizens also don't understand what fiduciary means. And therefore, it's a common practice quite often amongst PIOs when they don't want to give information, they say it's fiduciary. Their simple logic is people have trust in government, and therefore they give information, therefore this is a fiduciary relationship. Wrong. A standard fiduciary relationship is doctor-patient, lawyer-client, banker-customer, and so what are the characteristics of such relationships? A, somebody gives information to somebody with superior knowledge in that subject for his or her benefit. A banker, doctor, lawyer, or anyone else I give information to in a fiduciary relationship has to act in my benefit with that information. That is why I give that information. B, I have a choice whether to give the information or not. There is no legal requirement to give the information. C, I can choose who to give it to and whether to give it or not. This is not 99% of the documents in public records do not meet the condition of being in fiduciary relationship. Incidentally, there was a famous case of RBIs. When I was a commissioner, various people had asked for inspection reports, audit reports, grading of banks, action taken against banks, and so on and so forth, which are all refused by RBI, claiming Section 8.1 and 8.1e. They said this is a fiduciary relationship. I had ruled that this is not a fiduciary relationship because it is the information is provided in fulfillment of statutory conditionalities. This is not fiduciary. This was challenged. There were 10 such decisions. All of them were challenged in high courts. went to the Supreme Court. Supreme Court has upheld all the decisions and said that the term fiduciary is being used by RBI to terrorize people. This is not a fiduciary relationship. Trust, yes, only when you trust somebody, but that is one of the conditions. Just because you trust, it does not become a fiduciary relationship. Information received in confidence from foreign government. This is the only place the word confidence or confidentiality has been used. If information is received from a foreign government, the government and the PIO says this was received in confidence, there is no further argument and one has to accept that. Information, the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purposes. If giving information would endanger somebody's life or identify information source given in confidence, this should be denied. Information which would impede the process of investigation or apprehension or prosecution of offenders. Please take a careful look at this. Quite often, when somebody has filed a complaint and no action is being taken, they file an RTI application saying what progress has happened in this investigation. And the standard answer often is, investigation is ongoing, therefore it will not be given. Wrong. The law does not say this. The law did not say process. Would impede, the word uses impede the process of investigation or apprehension. A PIO would have to show how there's a reasonable chance of the information leading to impediment in the investigation. 70% of the times the person asking for details of investigations are people who have filed the complaint. It is laughable to say that the person who's filed the complaint will impede the process of investigation and impede the process at all. Cabinet papers, including records of deliberations of the councils of ministers, secretaries, and other officers. Provided that the decisions of councils of ministers, the reasons thereof, and the material and the basis of which the decisions are taken, shall be made public after the decision has been taken and the matter is complete or over. This is a very unique exemption. Information is exempt until a particular set of points, until the decision is taken. Once a decision is taken, the law requires the information to be shared publicly with the public. To give an example, most bills are presented in Parliament. There is usually there is expected to be a series of discussions in the Council of Ministers with the secretaries, with the government's bureaucrats, and maybe even other people. Until the decision is taken, it is to be kept confidential. Once, let's say they present the bill in Parliament, the matter is complete or over, then it is the property of the Parliament or state legislature, and they may do what they want. The whole concept is that once the bill is presented in Parliament, the whole reasoning should be declared publicly so that public can also discuss the pros and cons. We legitimize members of Parliament and members of the Legislative Assembly. We are the people who legitimize them. They don't legitimize us. Therefore, we must have an opportunity to discuss, and that is what a true democracy should mean. 81J is the most misused exemption by public officials. Let's read this. Information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual. Larger public interest we'll deal with later. Provided that the information which cannot be denied to Parliament or state legislature shall not be denied to any person. Note carefully. If it is personal information, what is personal? Anything related to a natural person is personal. Your age is personal, your name is personal, your telephone number is personal, the color of your hair is personal. If you write a note, who wrote that note? Mr. X wrote that note. So it is related to a person, it is personal information. But being personal information, it may qualify. There are other requirements. The disclosure of which has no relationship to any public activity or interest. I repeat, 99% of the information in public records is the consequence of a public activity. It's not a private activity. What you do in your house doesn't go there. What you eat does not go there. Unless what you eat, the bill is paid by the government, then it's a public activity. Or if it's not a public activity, or which would cause unwarranted invasion of the privacy of the individual. Now, what is privacy? Puttaswamy judgment said privacy is a fundamental right of citizens. Yes. It's a fairly huge judgment. Go through the entire judgment, you do not figure out what is privacy. So how is one to decide? Parliament was aware, and we were aware when framing this law that such a problem may come. It will be difficult for a PIO to decide on public activity, private activity, what is privacy, what is invasion of privacy. The Supreme Court in Puttaswamy has said we will decide on what constitutes privacy on a case-to-case basis. Therefore, an acid test was given to this provision only. Provided that the information which cannot be denied to the Parliament or a state legislature shall not be denied to any person, which means whoever is denying information claiming exemption under Section 81J must make a statement that I would not give this information to Parliament or state legislature. When can such a thing arise? If you look at Article 19(2), just look at the words interests of sovereignty and integrity. Privacy will not have anything in common with the interests of sovereignty and integrity of India, security of state, etc. There are only two words which will relate with privacy, that is decency or morality. If something violates decency or morality, it should not be given to Parliament. It is privacy. It is an issue of privacy. Apart from this, all of the information must be shared with the people. And Section 81J is, as I said, used in 50% of the time when a PIO does not want to give information. He says it is personal information, hence I will not part with it. This is not sanctified in the law. If you are not satisfied with the PIO, there is a provision for a first appeal to a first appellate authority within 30 days. How do I know the name of the PIO? You don't have to know. You just think of the administrative office of a public authority and file an RTI application to the public information officer. Supposing the PIO does not respond to you or responds to you not giving you a satisfactory response, what do? You file a first appeal to a first appellate authority within the same department. It's a senior officer. How do you know who the first appellate authority is? The law requires a PIO to tell you who the first appellate authority is. In case he doesn't respond to you at all, then you send a first appeal to the first appellate authority, care of public information officer, and say that as per law, it was your duty to have informed me of the first appellate authority. Since you have not done it, you will transfer it to the first appellate authority. For not getting information, incomplete information or wrong information, first appellate authority should decide in 30/45 days. If result of first appeal not satisfactory, file second appeal to the commission within 90 days. Section 19(5) says onus on PIO the denial of information was justified. The way the law is structured, you do not have to say why you want information. But if information is denied to you, since something that you own was denied to you, PIO has to justify. But in actual practice, you may have to argue as to not why you want information, why the information cannot be denied to you. Appeal. Carefully look at the response and see if information has been provided. Information can only be denied if A, it is not available anywhere. If it is available with another office, it must be obtained and given. If it is with a different department, the application should be transferred. If it is exempt under Section 8 or 9, even when it is under 8 and 9, if you can show a larger public interest in disclosure. To give you an example, supposing you ask Punjab National Bank for Nirav Modi's account details. It is likely to be denied to you, saying 8(1)(e), this information is held by the bank in a fiduciary relationship. But you may well argue that there is a larger public interest because there is a big scandal that has happened. Therefore, there is a larger public interest, and you would have a case to fight and to get information. I'm not saying it will be given or not, but you have a reasonable ground. Section 20 is the teeth of the RTI Act. Without this, the Act would have been useless. If information denied without reasonable cause, Commission must penalize the PIO or deemed PIO at ₹250 per day of delay after giving an opportunity of explaining. Maximum penalty ₹25,000. Commission can also recommend disciplinary action against the officer and compensation to be paid to the applicant. This, as I said, is the teeth of the act. This is the only law that I have come across which directly penalizes the public information officer, a public servant, for not respecting your right. Directly. This establishes the fact that you are considered the sovereign of this nation. If supposing you were a Badshah or a Begum, and you asked a public servant some information and he said, nahi deta hu, or refused to answer to you, you'd probably send them to prison. Here we don't get to send them to prison, but they have to pay a personal penalty from their own salary. This is what makes the act powerful, and it recognizes the concept of sovereignty of the individual. Section 22 is important to understand. The provisions of this act shall have effect notwithstanding anything contained therewith in the Official Secrets Act and any other law for the time being in force, or in any instrument having effect by virtue of any law other than this act. Most laws get into a problem because somebody will say the Banking Act says this, somebody will say the company law says this, somebody will say the RBI rules say this. This law overrides all other laws as far as giving of information is concerned. As far as giving of information is concerned, nobody can say because of banking law, I will not give this information, because of Supreme Court rules, I will not give. It has to be given as the law stands. The RTI Act, in terms of getting of information, mind you, this is only getting of information. It is not a grievance redressal mechanism, though sometimes it does redress grievances. To put this whole thing in a nutshell, RTI application, information in 30 days. If no response provided or unsatisfactory response, first appeal to be filed within 30 days of response or 60 days in case of no response. First appellate authority, order after hearing within 45 days. If unsatisfactory order or no response, send appeal to commission within 90 days of first appellate authority order, or 120 days from the date of first appeal if no order received from first appellate authority. Now, here I'd like to tell you one or two instances of usage of RTI. This relates to now some state governments have formats, some don't. Central government has no format. I'm showing the Maharashtra format. In case your state government has no format, you can use this format if you like. The key thing is the information that you see. The story here is one young chap, 21 years age, came from a small village to Mumbai city looking for a job. Where did he stay? He stayed in a hut with an uncle of his in a slum. While he was going around looking for contacts, cousins, friends who could help him get a job, he noticed there was an RTI workshop in the Basti. He sat down, understood what is right to information, understood it's his fundamental right, understood the fact that he must get information in 30 days. What is information he understood? Understood that he can pay 10 rupees application fee. When he understood all that, he moved. He also understood that he does not need any form. Any plain piece of paper can be his form. And he can write it in hand or type it or computer generated. So he understood all this, then he moved on after the workshop. He got a job after a few days. Then he needed a ration card. So he went to the rationing office, gave his application. And as he was going out of the door, the peon accosted him and said, "Do you want a ration card?" He said, "Yes, that's the reason I gave the application." The peon in Hindi told him, "Chai pani lagega." This boy said, "Theek hai, aapko chai pila dunga." The peon said, "No, chai pani does not mean chai pilana." He said, "Then what does it mean?" He said, "You'll have to pay 2,000 rupees, then you'll get your ration card." This boy, without batting an eyelid, made a statement that always makes me feel very proud. He said, "I will not give a bribe." The peon shrugged, said, "Buffoon coming from village, he will figure out in a big city how life moves." He said, you go, you don't want the ration card." This boy continued his work. After 3 months, he gave this RT application, which I'm showing you. I'd given an application for a ration card on 5th August 2006. Photocopy of receipt attached. I want the following information about its progress in the following format. date on which application received, name and designation of the officer receiving it, action taken, date on which forwarded to the next officer. 2. I want a list of ration cards issued in the last 2 months, giving the dates on which the applications were made and the dates on which the ration cards were issued. He did not ask, why have I not? What he wanted to know is, why have I not got my ration card? But if he had asked that, there'd be nothing on record showing that because he did not give the bribe, he was not given. But this, what would he answer? What could the office answer? They could not say that the file has not moved at all since the bribe has not been given. They said that that would expose the corruption. And in the last 2 months, they had given ration cards to others after taking the bribe. So if they were to give that list, that would expose them. Next day, the peon came to his house and he said, the officer is calling you. This boy went to the rationing office. As soon as he went there, the officer told the peon, he said, अरे इनके लिए कुर्सी लेके आओ और इनका राशन कार्ड लेके आओ और एक कप चाय और एक गिलास पानी लेके आओ. He did not give chai pani, he got chai pani instead. And to me, that one cup of tea represents respect to the sovereign Indian citizen. It's more than that. It's not just a cup of tea. The power equation has to change. Public servants must treat you like rulers, and you must also treat the public servant like a ruler, because it's a negotiation of equals, the point I'm making is. And this sovereignty of the individual is established by this boy. Lakhs of cases like this have been used all across the country for ration cards, for income tax refunds, for attending to complaints, for getting action on representations or other applications. Same kind of wording is used in different manners, in different languages, and services are obtained from government. Now here I am showing you one of my own RT applications. This was before I became an information commissioner. I was just an ordinary citizen of Mumbai using RTI and also evangelizing RTI. One fine day, I saw a photograph on the front page of the Times of India because citizens were demonstrating at one place in Mumbai, protesting against the fact that one police constable, More, had raped a minor. On the same day, on page 5, there was a small news item which said that Police Inspector Prakash Avare of Mumbai Police had raped a minor in the earlier year. These were two different cases. The evidence was very clear. Inspector Prakash Avare was suspended from service. Case went to court. The court released him because they were not able to give enough evidence. And the report said that Prakash Avare was being reinstated in service. When we read such things, we feel angry. I also felt angry. And I filed this RT application and I'll tell you what happened. According to a news report in the Times of India dated 29th April 06, Inspector Prakash Avare has been accused of raping a minor girl in September 2005. He was acquitted by the Sessions Court in February and has been reinstated in service. I want a photocopy of the order reinstating him, along with the file notings based on which the decision was taken. I was asking something on record. I didn't say, why are you keeping him? You must not keep him. No, none of these talks. No taunting, nothing. Just ask for information, bare information. This was refused, and I filed a first appeal. The grounds for appeal. Facts of the case. I had asked for information regarding the reinstatement of Inspector Prakash Avare as per the attached application. The PIO first sent me a letter stating that the information would be provided by Bhaikala Police Station. PIO Bhaikala replied by his letter of 16/5/2006 that the information could not be provided as it was exempt under Section 8(1)H, which exempts information which would impede the process of investigation or apprehension or prosecution of offenders. Grounds for appeal. The PI has not shown how providing the information could impede any investigation. In fact, no investigation is being held since Prakash Avare is being reinstated. The rejection is without any basis in law. For the appellate hearing, the First Appellate Authority normally calls you for a hearing. And nowadays we are insisting that the hearing should be held virtually through internet, Zoom or WhatsApp or Microsoft or whatever you have. Well, at that time, this was physical. When I went for the first hearing, this was a very good deputy commissioner of police. He said, Mr. Gandhi, what could we do? As I said, I was just an ordinary citizen. He didn't know me. He said, but he understood, he was sympathetic. He said, Mr. Gandhi, what could we do? The court has released him. I said, sir, I'm only asking for a document. I'm not asking for anything else. But from my perspective, there are two possibilities. Either Prakash Avare is guilty of the crime he is alleged to have committed, in which case reinstating him would be against police interest of the citizens and the law. Alternately, I conceive he may be innocent. If he's innocent, somebody framed him. Some action should be taken. Somebody must pay for this. He saw the point I was making. He said, Mr. Gandhi, let me see what I can do. In 20 days, I got it in writing from the police commissioner of Mumbai that Police Inspector Prakash Avare had been dismissed from service. That is the power of right to information that one citizen, a single citizen, can use. This is a phenomenal instrument. Getting information can lead to lots of things, can lead to empowerment of citizens, can lead to active citizenship. And all of us must do it. Summary for central government, no specified format. Application fee rupees 10, most convenient to attach no fees for appeals. Online RTI application, first appeal can be filed at central government, Maharashtra, Uttar Pradesh, Delhi, and some other states may also have that. If you look up RTI online of your particular state, you can find that. People ask me, does every RTI application work? It would be a lie if I said yes. The fact is, it works at a certain percentage level. Then why file RTI? If you are the sovereign of this nation, correcting this nation is your problem, is your duty. Sovereign has an authority, but he or she also has a responsibility. If Akbar Badshah or Shivaji Maharaj or Tipu Sultan were ruling and something was not okay, they corrected it. They looked at it as their duty. Correcting this government, correcting our democracy is our duty as individual citizens. And RTI gives us a simple route. Filing one survey I have conducted of people, and I've found that almost all Indian citizens crib for about 2 hours every month about what is wrong with government and the nation. Roads are not okay, police is like this, minister is like this is that way, pollution is like this, somebody is taking bribes, and so on and so forth. With this cribbing, can anything change? Ask yourselves. Nothing can change. Then why do we do it? Got used to it? My submission is, out of that, spend half an hour on filing one RTI application every month. What can happen with this? If 30 lakh Indian citizens or 50 lakh Indian citizens were to take a vow that they would file one RTI application once a month on a topic that concerns them, something they see in the news, something they feel is wrong, try and see if they can file an RTI application relating to that. If 50 lakh citizens file RTI applications once a month, 6 crore RTI applications will be filed in a single year. Will all of them work? The answer is no. In the initial days, about 30-40% used to lead to some result. Now, because of variety of problems, the percentage is probably about 15 or 20%. Sometimes the information may not be given to you, but some small correction happens in the government. If 6 crore RTI applications are filed and 15-20% of them have some impact, 1 crore times a year, if a small change in governance occurs, in 5 to 10 years, India would be a different nation, a democracy we can all be very proud of. Not merely an elective democracy, but a participatory democracy. That is what RTI is all about. At one talk, when I was giving this, there was an old man my age. He got up and said, Mr. Gandhi, India में कुछ होता ही नहीं है. Nothing will work in India. I have tried, I filed complaints, I made RTI applications, nothing happens. Nothing will happen. India में कुछ हो ही नहीं सकता है. To such people I say, many of us go to mandirs, masjids, gurudwaras, churches, agyaris, what have you, once a day, once a week, once a month, maybe once a year. When we go there and come out, do we have an extra 100 rupees in our wallet? We don't. Have we become more handsome, beautiful? Our hair has become better. We feel younger, more energetic. Nothing like this happens. And yet, why do we do it? We do it as an act of faith. We have faith that by doing this, something good will happen for me, my family, my city, my society, my nation, whatever you. It's an act of faith where we can't see a logical connection, but we do it as an act of faith. What do we do for the nation as an act of faith? Zero. Can we try this as an act of faith for the nation? Don't worry about what can happen. And you can see that there is a possibility that something can happen. The police inspector Prakash Avre case I gave was not because of me or RTI so much, but it helped an honest police officer to do something. We need to support honest police officers and other public servants also. We don't support them. We need to do something. Do it as an act of faith for the nation. There's a lot of talk of patriotism. People say you must shout certain slogans, sing the national anthem, stand with respect before the national flag. Yes, do all this, but these are symbols. These are tokens. They will not change the nation in any way. If you participate in the nation, are concerned with the nation, concerned with your responsibility as a sovereign Indian citizen, believe that you are the Badshah or Begum of this nation, we can together make a great change. Without that, no change can occur. And therefore, I'd like to share this last slogan before I finish. Mera Bharat Mahan. Lots of places people write, say, but they don't really believe it. And therefore I say, Mera Bharat Mahan nahi hai. Mera Bharat Mahan nahi hai, par ye dosh mera hai. I, the individual sovereign citizen of this nation, am responsible. The responsibility is mine. Nobody else's. And only I can make the change. And I must make that change. Thank you, friends. Thank you very much. Now I'd like to open up for questions. If possible, see if some people can ask questions directly also instead of doing it through the chat box. I'd be quite happy. And one specific request to all of you is challenge what I said. Do not accept anything that I say. Feel free to challenge. Say, Mr. Gandhi, you are wrong. This is not what democracy means. You are wrong. This law doesn't mean this way. You are wrong. This law is wrong. I will try and answer and I will learn out of that. And I keep learning out of these experiences. So feel free to challenge anything that I say. Do not look at it as a docile question answer session. Challenge. And that way we'll both learn. Thank you, friends. Thank you very much.
Thank you, sir. It's a pleasure to be on the Neeti forum to witness this day. The meet is now open for questions and interactions with sir. With permission, the volunteers are now requested to take over. The names will be called upon chronologically, and the participants with questions have to turn on their cameras while they request information. The first person who will raise question is Ms. Kajal Prasad.
Good evening. Am I audible?
Yes, ma'am.
Hello, sir. It's been a very informative session. Thank you for that. So my question would be, more than question, I think I would like to say that RTI is definitely a great tool, sir, to gather or seek information. But I personally feel like it's lacking in its implementation. So why I would say this is because there are 2-3 points. First thing is that generally, not everybody is an RTI activist, right? So I feel like there's a certain set of skill that is required to frame your RTI question. For example, whatever you said about that person from Mumbai who went and filed an RTI application, he did not directly ask that why is my ration card, why have I not received it, because if he would have asked it that way, it would have been rejected. So not many people know this. The problem is that what, why, or how questions are generally rejected. So there is this kind of a skill that is required to actually file it, and not many people know how to file that. And secondly, one more thing is that now more and more people are getting aware about RTI, and people are starting to look into this. But I feel at the same time, the government officials are also getting more and more smart. So they find ways how to dodge the questions. They even if there's a slight mistake, even if they probably understand the question as to what the person is trying to ask, they straight out reject the question. They don't answer it. So what would be your suggestion, sir, to improve this or make this better, so that it's accessible to everybody?
First, I'm hoping that all of you will start using and teaching at least 5 other people how to use RTI. And you are all much younger and smarter than me, and budding lawyers. So you will do a much better job at it. Simple things, just explain to people that you can't, there's no harm in asking a question, legally speaking. The law does not say you can't ask a question. But the answer, if there is a record available, it must be provided. However, since, as you rightly pointed out, a lot of people say question mark hoga to hum nahi jawab denge. Avoid that. Just tell people a simple thing. Therefore, I've given some examples also of my RT applications, which you can take a look at. Think of a simple thing, and even if you don't get it right first time, try a second time. This is not a very expensive thing, not too time consuming. It will not take more than half an hour of your time at best. And the cost is 10 rupees, 20 rupees, 30 rupees. If it's an RTI online, just 10 to 15 rupees or with postage. That's all it costs. Unless you use it, you don't get to learn it, is my overall submission, no matter how much you train. Incidentally, on YouTube also, there are lots of workshops by me and by others as well. And I'm sure all 60 of you have understood how to frame an RT application. If you have, teach others, my friends.
Actually,
yes.
That is where my question came from, sir. So we had a practical we all were asked to file an RTI application so that we know how it works. So what happened is most of our RTIs are actually rejected, even though we have it as a subject, even though we know how to file it and we did it, and still most of our applications is rejected. So that got me to think that, if our applications are being rejected, what about the normal people? Who
I can assure you, at least 30-40% of those rejections are illegal.
Okay. Yeah.
Take a careful look, file an appeal. What has happened? Let me be honest. The Information Commission was supposed to be the pivot around which the RTI would move. The father of RTI in a way. Most information commissioners have no predilection for transparency. They look at it as a sinecure. And this, incidentally, is not true just of information commissions. This is true of human rights commissions, women's commission, children's commission, Lok Ayogs, the whole bag of them. Lokpal, for example, you may have been very young, but 10 years back, people on the roads of India, in lakhs of people, saying we want a Lokpal. Now we have a Lokpal, what does he do? He does zilch. Most of our commissions are like this, and that's a separate matter which I would deal with. But because of that, government officials are also feeling, but if there is a people pressure, we need to build that pressure. What we need to understand is 75 years back, we did throw away a foreign government from ruling us. Now it's our government. But we need to build pressure. If you don't build pressure, nothing will happen. We have a great tool. We have one of the best RTI acts in the world. I've studied some of the RTI Acts, and this is one of the best RTI Acts in terms of its provisions, but being misinterpreted by commissioners, by judiciary and PIOs, which is sad, which we need to explain to them that what benefits citizens benefits everybody. Citizens and government officials are not at two ends. They both have a common interest. We all have an interest in India. But we'll have to struggle for it. I concede that, Miss.
Thank you, sir.
Thank you, sir. The next question by Dr. Ravi HG. I request Dr. Ravi to raise the question. Okay, sir, we are moving on to Satish's question.
Good afternoon, sir. Thank you for your the wisdom you shared with us. Sir, my question is basically related to what is your suggestion or to both the RTI seekers and to the government on how to protect the RTI seekers or the people who are looking for RTIs, but in the process they get either murdered or they get attacked, like the recent incident which happened in Karnataka where one person was killed. So what is your suggestion there?
See, it is a question of a lawless state, which to some extent we are. Anybody who challenges authority or tries to expose something which is corrupt or wrong, it's not through RTI. It is because you are challenging wrongdoing. It is because you are challenging somebody who is breaking the law. There is no perfect solution. One thing which I do promote is that I ask all information commissioners that if anybody is attacked or is killed, order all information that is sought to be released on the web. That may act as some kind of protection. But 100% protection, I am unable to think of. Having said that, the risk is not as high as is made out. You see, ultimately, in any day in Mumbai, about 100 people lose their lives in various accidents. Totally about 100 people have been killed as RTI users, I concede. And there is no, if I give you any false assurance, it will be wrong. But I'm only saying the risk is very small. And I tell people that if you feel you don't want to take a risk, don't take a risk in areas where there is likely to be a risk. Decide on other things. That risk and safety factor has to be decided by each individual only.
Thank you, sir.
So the next question is from Mr. Arjun. He has network issues, so he's not able to join us today. I will be representing his question. In Ashish Kumar Saxena was a state of Uttar Pradesh, which is decided on 9 July 2021. The Honorable Supreme Court stated that RTI replies are not very reliable. So what is your view on the same?
No, this incidentally, I had actively sought clarification, and I have spoken to one Parasnath Singh, a young, bright lawyer who's fairly well reputed, who was in the court on that day. He also writes for, does work for the leaflet. And he said this was, the actual case was that there was a plan in which the area was not shown as residential. And there was a PIO's response together with that in which he said this is residential. So the court said in this context, it was very contextual. It was not a general statement, which one reporter blew out of proportion. And unfortunately, sometimes these things sound very exciting, interesting, sexy, and therefore everybody goes and washes them everywhere. The court did not say this. It's not part of any order, even verbally. Parasnath Singh, who's a very young and bright lawyer, he told me, he said this was not in that context at all.
Thank you, sir. Dr. Ravi Hedgie is present, so he'll be asking his question now.
Yes, sir. Good evening, sir.
Good evening.
Thank you very much for a nice presentation. My question is whether the RTI application is maintainable against the private organization like private hospital, etc., sir?
No, you see, the private hospital is not obliged to give you anything unless you can show it is subsidized by the government or controlled by government, or supposing it has got government trustees or something like that. If it is none of these, but information that they are required to file with government statutory authorities is accessible to you.
But one of the sir, definition class is very clear. In last part of the definition class, there is against the private hospital is only for the serve for the society. In these are all circumstances, the RTI application is maintainable. Is given for so many in the case last.
No, sir, that would be a wrong interpretation in my opinion. Yes, information of a private body which can be accessed by a public authority. The law categorically states this. So if it can be accessed by a public authority, then of course you can get it from there. Supposing the public authority should have got, as an example, an annual return from the hospital, but it has not got that. If you ask the public authority, they are duty bound to get it and give it to you. But it must be something that they can access, not otherwise.
Okay.
Thank you, sir. The next question is by Navyashri.
Good evening, sir.
Good evening.
Thank you for your enlightening speech. It's my personal question. I'm very curious to know what inspired you to become an RTI activist from being a first-generation entrepreneur.
Okay, the story in short is I was doing my own business, and when I was in college, I was an organizer, debater, and so on. So one professor asked me about 20 years back at a alumni program. He said, Shailesh, when you were here, you used to say things are not okay. Society is not okay. Government is not okay. What do you think now? The first reaction was things are not okay. But then I also thought at 20, when I said things are not okay, it was implied that we will do better. At 50, when I was answering this query, I was society. And things were not better. So I felt responsible. And that's why I decided to sell my business and try and do something relevant for society. Incidentally, one other thing I'd like to promote is, maybe if I have an opportunity sometime, judicial deliveries must happen in limited time. And virtual courts are absolutely essential right now. There are very powerful lawyer lobbies who are fighting that. Anyway, does that meet your question, Navya?
Yes, sir.
Thank you, sir. Ms. Bollama may now ask her question.
Good evening, sir.
Good evening.
So I'll be a little candid here. Also, it was a very informative session. Thank you for that. So you mentioned in the beginning that we are the rulers of this country and everybody has to know that. But I personally feel that people at large do not believe in the same concept. They're somehow bound by this thought process saying the government is above us, or somebody else is ruling us. So I think it is very important that we should create awareness, impacting the larger consciousness of the people. If personally, if I now I'm a law student and now I know the power behind RTI Act, so that's how I'm aware of it because I'm studying the course, right? How do we let the younger minds, basically the ones who can get influence in a very younger age, how do we impact the minds of such younger brains, and let them know that they have the power to question the government and they can bring about changes? How do you suggest that, sir? How do we change that?
First, use RTI yourself to explain to people how to use RTI. Let me tell you a very interesting story around similar lines. The year was 2006. There was a RTI conference in Delhi, which I had gone to attend from Mumbai. There were about 120 people in that hall. The age group was 17 to 70. In the afternoon, I saw a young 10-year-old boy walking in with a senior person holding his finger. I was wondering, I said, what's this 10-year-old kid doing in this RTI conference? This is way back in 2006. And then he told us his story. The story was like this, and it's worthwhile understanding. His bicycle had been stolen. His dad had bought him a new bike, and the bicycle had been stolen. And the police station was quite close to his house, within walking distance. So he told his dad, he said, let's go and complain to the police, my bike is stolen. The dad first said, no, since this kid was insistent, he said, okay, let's go to the police station. They went to the police station. They met a police inspector, and they explained to it, this boy explained that I have lost my bicycle. Please find it for me. The police man said, yes, we'll find it and give it back to you. They went back. After 3 days, the boy came back again and said, uncle, have you found my bicycle? He said, no, go. Twice or thrice this boy did this, so this inspector got very angry. He said, look, if next time you come here, I'll put you in the prison. So you don't come here. When I find the bicycle, I'll give it to you. An RTI activist happened to come to this boy's house. So this guy would tell all guests, police aisa karta hai, police is not helping me to. So this RTI fellow said, will you file an RTI application? He said, I don't know what it is. He said, I'll help you. So they made an RTI application saying, on such and such a day at such and such a time with my father, I gave a verbal complaint to so-and-so officer. I want a copy of the complaint from the police register. See, when you give a complaint, the police is expected to write it down. That's the law. Most often, this law is breached. So they gave this RTI application. Next day, the same police officer had come to their house, and he tried to talk to the mother, saying, look, your son has given an RTI. The mother said, talk to my child, because he's the one who's filed it. And the police fellow told the chap, he said, take your RTI application back. I'll get you a new bicycle. And what that boy said was amazing. I'll never forget my life. He said, I told the policeman, I do not want my bicycle. I want a reply to my RTI. He understood that fighting for his rights to see a better society is more important than his bicycle. 10-year-old child. You're all senior. I'm hoping you will leave this evening feeling that I am the Badshah and Begum. And yes, it will be a struggle. I'm not saying it's easy. But only if we can do it, and no political leader is going to do it, no government is going to do it for us. You all are right, government officers don't think like that. I often talk to government officers and I try and explain to them. They nod at that time, but after the talk is over, the whole story is forgotten. A government officer also benefits with what benefits citizens. It's not, he's not outside the society, outside the country. But that's a longer haul. Does that satisfy you, friend?
So I do agree with your whatever you said, but don't you think we should add in a syllabus, as in a topic in our textbooks, in the early stages, so that kids can know?
Oh, that'd be lovely. We've been trying to promote this, not very successfully so far. But yes, I completely agree with you. RTI should be, democracy should be part of our syllabus. We say we are a democracy, we don't know what a democracy is. We don't even test it on that simple premise of saying rulers of the nation.
Yes.
We the people say we give ourselves a constitution, we don't even test that against anything. Nor does the Supreme Court test it. We will, you and I am now past my prime, but all of you can do it.
Okay, sir. Thank you. Thank you very much.
Concluding with the last question being, would you like to recall or recollect anybody who might have helped you become who you are now?
Well, in a way, Aruna Roy, I happened to meet her in 2000. In 2005, for the first time, I heard of Right to Information. 2003, sorry, my apologies. 2003, I heard of RTI first. And Aruna Roy had come to Mumbai to meet another friend who knew that I was getting interested in Right to Information. So she brought Aruna Roy to my house. And Aruna pitched me into the national stream. We had a discussion on Right to Information. To me, she's my guru in Right to Information. I don't necessarily agree with everything that she does, but I have due respect, and the truth is, India owes a lot to Aruna Roy for RTI.
Thank you, sir. Apologies to the participants who were not able to raise their questions today. Sir, JSS Law College Autonomous and the Neeti Forum is grateful to you for interacting with the students and clearing the ambiguity. I now request Mr. Pratyush to render the vote of thanks.
Good evening, everyone. My name is Pratyush Saxena, and I take this opportunity to propose the vote of thanks on behalf of the Neeti Forum and the JSS Law College Autonomous. Firstly, I express my heartfelt thanks to Shri Shailesh Gandhi, former Central Information Commissioner, who, in spite of having a busy schedule, graced the occasion with a thought-provoking lecture. I also express my gratitude towards Professor K.S. Suresh, Chief Executive, Dr. S. Nataraju, Principal of JSS Law College Autonomous, Mr. Pranav Nair and Ms. Sneha Jagdish, Faculty Coordinators of the Neeti Forum, for their guidance and moral support to organize this webinar. I thank Mr. Madhu Kumar and Ms. Nikita Susan for the technical assistance and all the members of the Neeti Forum for their cooperation and hard work. I also take this opportunity to thank each and everyone being a part of this webinar and making it a grand success. Thank you.
Taking your leave for the day, I thank every one of you for being a part of this event and making it a fruitful one. Thank you, sir.
My salute to all the Badshahs and Begums.
Thank you, sir. Thank you once again from our law college. Thank you, sir. Please do come to our college when you are
Sure.